All right, welcome back to the Judicial Proceedings Committee. We are back on voting list number 9. Jamie, we're going to start off with Senate Bill 373.
Thank you, Mr. Chair. Senate Bill 373 generally prohibits the knowing or willful theft of mail or an arrow key or other device used to gain access to a mail depository. The bill also establishes graduated penalties based on 1, the number of intended recipients for the stolen mail, 2, the type of information contained in the mail stolen, or 3, the status of the intended recipient of the mail stolen as an elderly person or disabled person. There is one amendment in your voting packet. The amendment number is 853-326/1. That's for Senate Bill 373. It is 853-326/1. The amendment strikes provisions of the bill and alters the state's existing letter theft and breaking statute to include prohibitions on first, the theft of mail up to 15 items, second, the theft of mail over 15 items, third, the theft of mail using an arrow key, and finally, possession of an arrow key. One additional note is that a conviction for violating any of the bill's prohibitions does not merge with a conviction for any other crime based on the acts establishing the violation.
You'll remember the hearing on this bill. The U.S. Attorney's Office for the District of Maryland is overwhelmed in this exclusively federal crime. So this allows the state to prosecute as well. The bill came in a very complex form. We've stripped it down to its kind of bare bones and did so with Eric's office and with their advice. So with that, Mr. Chair, I'd move the amendment.
So in a motion to move the amendment and seconded, is everyone okay adopting the amendment? All right, now the bill is before you as amended. Further discussion. Senator Carter.
I don't want to slow things up, but is the bill now in the form with its amendment in a posture where it somewhat mirrors the prosecutions, the federal prosecutions, so it makes us in parity with whatever how they prosecute in the wording of their statute?
It's not exactly the way the federal setup is, but it is compared to the way the bill came in. The bill is much closer to what the federal government structure is, and we use the federal statute in order to create the amendment that's in front of you. So, so it's much tighter than it was.
Okay.
Yep.
Thank you.
Thank you.
If you do look at the reprint, the existing statute, the question was, what does it do to the existing letter taking and breaking statute? And if you go to 6.8, that provision, now there are penalties. The penalties and prohibition essentially stayed the same, except that what had to go with theft became part of the new language. But on page 8 of 8 at the bottom, B1 would retain the existing law, and then B2 through 4, and then also C would be the new prohibitions. And you can find on the last page, the back of the printout, the penalties. So for just the breaking of a letter without permission of the person to whom it's addressed, it would retain its current penalty of 6 days and a fine of $15. However, as I indicated, the graduated penalties would apply to those theft provisions.
They felonies in federal as well?
That's correct.
And what's the most minimal thing a person could do to get a possible charge and conviction for the felony?
So under
for the
bill,
lower felony.
So in the federal system, it is only a felony. So in the federal system, you steal one piece of mail and you are a felon. We decided that that's not appropriate here. And we want to bifurcate between smaller scale and larger scale thefts. And so here, it's a misdemeanor, for example, for one piece of mail, up to 15 pieces of mail. Above that, it becomes a felony, and the arrow key, use of the arrow key, which the U.S. Attorney indicates is kind of the indicia of the larger criminal operation, is also a felony.
Just real quick.
Oh,
Real quick, I didn't have anything to say on this at all. But I'm wondering, so in my limited experience, I've been in federal court before, and the most cases I saw were like people that worked for the postal service and they stole mail from their job, and that's what the prosecutions that I've seen, the few. But in my own experience, and maybe some of you, and we've all probably had this, you know, the mail carrier makes a mistake and I'm opening my mail and I open something, I see something that doesn't pertain to me, and I'm like, oh no, it really wasn't directed to me. In that case, I technically violated the law for that could go with the 6 days. I broke the envelope. I mean, it was a mistake, so probably I wouldn't get a conviction because it was an honest mistake and the mail carrier delivered it to me. But just wondering, how far does it go?
Well, I mean,
I could be prosecuted.
it's interesting. So the statute that you're talking about dates back to, I think it was the 1600s or early 1700s. I don't know if there's any case law. I could look into that on whether or not there's a knowledge requirement. A lot of times where the General Assembly has been silent, courts are left with the determination of whether or not the General Assembly intended something to be strict liability, or under the rule of lenity would need to read in, that there's knowledge, a knowledge requirement. I could look into that. I wouldn't believe it's a strict liability offense, but I could look into it. It's certainly, the statute's been around long enough. I don't know when
Just
the last
curious,
time
that's a
it was
legitimate thing that
was.
has happened, and it actually seems like it's gotten more prevalent in recent times than it ever used to be. Just to mail people just make a mistake and just put the wrong mail in your pile, and you're going through your pile, and next thing you know, you've opened up a mail that wasn't addressed to you. It could happen. It does happen. It has happened.
And just for the record, I did this last week where I opened someone else's mail accidentally, but I don't think that's what's happening here in the statute. I think we're good to go. This is for people who are stealing mail.
So let's say it's my next door neighbor and I opened it by mistake. I realize it's not for me and I go and take it to them, and then they don't like me. So they could file charges ostensibly because I opened their mail. It was good. Just
I don't think that's the case.
okay.
Takes out the words take and.
Right.
So it used to say a person may not take and break open a letter not addressed to them. Now it just says you can't open it.
Senator, is because the taking is really covered by the new theft provisions for taking mail under B2 through 4. So what's being prohibited in B2 through 4 of the amendment is theft involving items of mail. And taking was removed to avoid duplication.
But now what you've got left is it's illegal to open a letter that's not addressed to you, which, as Senator Carter says, we all do from time to time because
Sure.
the post office is not very efficient getting the right mail into my house.
Sure. So
So, Jeff, why is this not a problem?
Because I think as Jamie indicated that that courts aren't going to read behavior that has no mens rea attached to it, no intent attached to it as being a criminal act. That where we don't specify the intent, they're going to assume that it requires some level of intent. This isn't a strict liability crime.
So Jamie is in fact, if I were indicted for doing this, would a court say, well, Senator West is not liable because he really didn't intend to do this? Is the court going to import a mens rea requirement there, the intention to break the law?
well, it's a question, right? There have been cases where the court is looking at the legislative history to try and determine what exactly the General Assembly meant when they did something. And my reading of the case law and my understanding is courts generally prefer when the General Assembly is clear about what it intends.
So would it be helpful to do an amendment that says a person may not, comma, with intent to open someone else's mail, comma, break open an item of mail that's not addressed to the person?
It's just cleaner to add knowingly, a person may not commit.
Oh, you're,
Because we have to satisfy both elements. That they can do, but you're getting a lower.
See where it would stop somebody from being charged. It would just be a defense that they could offer. Do you know what I mean? Like, I didn't mean to, because that's usually something that's meted out in the course of a trial, whether they intended or their intention, but they're not looking at it always at the charge level. So it could maybe be tightened up a little bit, I think, but I don't think this is a common thing, and I don't think I don't think there's prosecutors out there dying to prosecute anybody for opening mail. So I don't think it's a real huge problem, but we probably could tighten up the language a little bit.
Intentionally. What, I mean, why don't we just? With that. Chris, why don't, in B1, why don't,
Intentional volunteer?
would that work for you, Chris?
If I break open a letter, I'm doing it intentionally. I'm breaking it open and taking the letter out.
You want to keep taking?
Huh?
Take? But take
No,
is
'cause
loose
that-
too,
'cause
because if it's in your
that's theft.
mailbox and you take it out, you took it.
No, my thought was a person may not, comma, with intent to open someone else's mail, comma, break open an item of mail, et cetera, et cetera, et cetera.
Okay.
All right. A person may not, comma, with intent to open someone else's mail, comma. Then go to the existing language, break open an item of mail, et cetera.
I think you get the same result. The person may not intentionally break open an item of mail that is not addressed to the person without permission.
That's fine. That's fine.
Let's just adopt the senator's amendment that you have in writing before you, the interlineated copy first. And then we'll add the West language to that. Is that okay? All right. Can you read this back one more time, Jamie?
Sure. So just the wording that's being changed in the reprint in 3905, the language which is the language being added in subsection B1 would now read, a person may not intentionally break open an item of mail that is not addressed to the person without permission from the person to whom the mail is addressed, or the personal representative of the addressee's estate.
All right, is everyone okay with that? Do that in line. All right, now the bill is before you as amended. Further discussion. Motion is for favorable. It's been seconded. Is everyone okay being reported in the affirmative? All right, Senate Bill 373 with amendments passes unanimously. All right, this one's not on the list. Senate Bill 873. It's not on the list, but it's 873.
Senate Bill 873 extends from 10 to 60 days after the birth of a newborn, the time frame during which a person can leave an unharmed newborn with a responsible adult without the intent to return for the newborn without being subject to civil liability or criminal prosecution. A person is also authorized to leave an unharmed newborn at a designated facility. The bill authorizes a designated facility to receive a newborn in a newborn safety device as specified. Subject to existing funding, the Secretary of Human Services must develop, implement, and maintain a public information program about the Maryland Safe Haven program. By December 31st, 2025, and annually thereafter, the Secretary must provide a report to the General Assembly on program metrics as specified.
It's been seconded. Just further discussion. Does everyone understand the concept here? Sure. Yep. Go
Sorry,
ahead, Senator Kelly.
love the concept of the bill. Love the sponsor, just reading the ACOG letter that says they don't understand what a newborn safety device is. Do we have any more information on that? Are we comfortable? I mean, I'm just reading their letter of information. I don't know that statutorily that it matters what they're raising. There's no research or clinical evidence of the safety of or appropriateness related to the device that is described in the legislation. Before advancing the legal framework provided in this bill, there should be clear and uncontroverted clinical evidence supporting the use of these devices. Just reading it because since the bill wasn't on the list, but I'm not opposed to moving it. I just want to make sure the committee is aware of that.
The point of the clinical, they have already the ability to do this, and they just haven't done it. And so you're not gonna be able to have clinical data if you don't do it. As for the boxes and all that kind of stuff, it's a program that's been around. I think there's 12 other states. I'd have to get my file that already do this. And so the funding actually will come from the program as well to do it. So as long as it's a 365, like a firehouse or government building, there is about $500 worth of utilities that would be a yearly cost.
So it sounds to me, what I'm hearing from you is that 12 other states do this and we haven't. Obviously, the ACOG letter would include negative health outcomes or anything like that if that was happening.
Correct.
Okay, thank you. I'm comfortable.
Senator West.
I never turn my light on. So
Okay. Further discussion? Motions for favorable? Is that okay being recorded in the affirmative? All right, Senate Bill 873 passes unanimously.
Senate Bill 49 alters statutory Senate Bill 49 alters statutory provisions that prohibit unreasonable restrictions on land use related to installation of a solar collector system under specified circumstances. The bill specifies that a restriction on use is unreasonable if application of the restriction to a particular proposal either one, increases the installation cost of the system by at least 5% over the projected cost of the initially proposed installation, or two, reduces the energy generated by the solar collector system by at least 10% below the projected energy generation in the initial proposal. The bill further specifies actions that a community association may take in regard to the installation of solar collector systems in the common areas or common elements of the development. And there are no amendments. And to note, we did hear this bill last year. There were amendments that were suggested. This bill incorporates those amendments. I don't believe we passed it.
All right, discussion. It's motion for favorable. It's been seconded. One second, I'm just leaving it open for a second, just make sure. Senator James, yeah.
Bart, could somebody describe to me the context of this, when this bill would be applicable? This isn't about HOAs or anything, right? This is not like condos or HOAs, is it?
So this, it doesn't affect condos, but it affects, I'm sorry, it does affect condos. It affects any residential properties. But the thought behind it was that under current law, it was prohibited for there to be a restriction on land use that would significantly increase the cost of the efficiency of a solar collector system. But this kind of enumerates and kind of quantifies what actually counts as unreasonable. So a 5% reduction, let's say there's a restriction that says you can't have solar panels on this side and the other side is facing like a shadow, and that reduces the efficiency by 5%, that would be an unreasonable restriction. And so this is just to quantify what counts as unreasonable.
So, I don't see it restricted to, condominiums. It's, but I could be wrong. Looks like it's amending the real property article. I'm just trying to think of a real life situation, maybe that doesn't involve a condominium, where this would happen. So, and I guess what I'm thinking is this. If I don't understand the bill, this probably won't be a very good example, but you're living in maybe a housing development, and maybe maybe it has a homeowners association. Maybe that's where this would apply. And so somebody's gonna put a solar, energy system somewhere on their property, but maybe the homeowners association has some aesthetic restrictions, and and somebody decides to build something that's really outside the aesthetic restrictions in that homeowners association. Is that the kind of circumstance you think this bill would be? And would it even, and sorry, and then would it even be confined to that, since I don't see that it's confined to homeowners associations either? So I just want to kind of see where this would happen.
So
I apologize.
it defines restriction on use on page 2 at the top. And so restriction on use includes any covenant, restriction, or condition contained in a deed, declaration, a contract, the bylaws or rules of a condominium or homeowners association, security instrument, or any other instrument affecting the sale.
All right.
And so it defines a solar collector system. And then if you go down to B, a restriction on use, on land use, may not impose or act to impose unreasonable limitations on the installation of a solar collector system on the roof or exterior walls of improvements, provided that the property owner owns or has the right to exclusive use of the roof or exterior walls.
Here's the example I'm thinking of, Shamari. You have all kinds of land preservation programs. I'm under an MET easement, happily under it, right? And I'm got lots of restrictions on what I can do with my property. So my concern is that I don't know, maybe that's the policy we want, but those restrictions have this, I don't know if this would run into problems with those restrictions on, protected land under conservation easement. I still own it, fee simple, but there are quite a few restrictions on what I can and cannot do on that property.
Right.
So that's where I think I'm struggling the most. And I don't know how to square that.
Let's hold it until.
We should get something.
Yeah, we'll do that. All right, so hold Senate Bill 49. We're gonna hold Senate Bill 68. So that's the first page is completely disposed of. Yeah, we're gonna come back to that. Sorry. Senate bill, let's go to Senate Bill 400.
Senate Bill 400 authorizes a corporation to adopt emergency bylaws and establishes related provisions applicable to an emergency as defined in the bill, clarifies statutory provisions related to a corporation's acquisition of its own stock, and alters specified definitions.
The crossfire for this just passed 141 to nothing on the floor of the House. It's a modest bill that gives corporations the opportunity to pass bylaws which will define what is an emergency, and then give them the right in the event a catastrophe occurs to have meetings without the full quorum that they normally would require. So Charles, there was no opposition. Charles asked some questions, but Charles told me afterwards that he's not going to oppose the bill. But
They were good questions, though. I mean,
yeah, they were good
yeah.
questions.
Come up through the Maryland State Bar Association. Yeah, okay.
Sections.
Got it.
Are there real world examples of this that actually happened?
Let's assume instead of losing 14, let's assume instead of losing 14,000 people in the pandemic, we lost 1,400,000 people, which happened in the Middle Ages and the Black Death, the plague, could happen at some point here. If that happened and 3/4 of the board and 3/4 of the stockholders die, there has to be a way for the corporation to go on. So this lets them anticipate that, adopt bylaws which would take effect in that unlikely event and save them.
So the board of Pfizer should adopt bylaws that take their own vaccine. And then we won't have to pass this bill. All right. Okay, further discussion? Are there any amendments? There are no amendments. So motion for favor and seconded, Senator Sinner.
And Senator West properly talked about our conversation. I think it's silly, but I'm not going to stand in the way of some bill that's not necessary.
All right, now the bill's before you as amended. It's been motion. Sorry, you're right. There's been motion for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, excellent. All right, now, Josh, and then Senator West, we need your help here because I still don't understand this bill. Senate Bill 429.
Senate Bill 429 repeals uncodified provisions of law known as the Maryland Vestry Act governing the Protestant Episcopal Church, Diocese of Washington, and codifies provisions applicable to every religious corporation formed in Maryland by a parish or separate congregation that is in union with or intending to apply for union with the Diocese of Washington.
So the Diocese of Washington is a diocese that includes the Washington, D.C. Well, years ago, the Episcopal Church called me and asked me if I would be there's a special term for it, one of their lawyers. And I got a quick crash course in the Episcopal Church. So the Diocese of Maryland, we assume covers the state of Maryland. It doesn't cover the Eastern Shore counties, which are part of the Diocese of Delaware. And it doesn't cover the Southern Maryland counties, which are part of the Diocese of Washington, D.C. It's basically Central Maryland and Western Maryland. That's the Diocese of Maryland. So this only affects the Diocese of D.C., which includes Charles, St. Mary's, I think it's Prince George's counties, and Washington, and Montgomery County as well. Yeah, it's the collar counties around Washington and Southern Maryland. So the Episcopal Church was originally the Church of England. Back before the Revolution, and it was the official church of the state of Maryland. So it was all part of the state. back then. And because of that, unlike most other religious denominations, which have the right to do whatever they want to do, the Episcopal Church remains licensed or chartered under the state. And so what this bill essentially does is free up the various parishes of the Episcopal Church of the Washington diocese and tells them they should adopt bylaws, their own bylaws. So in a nutshell, that's what this bill does. And I wasn't here when the bill was presented, so I don't know what the presenter said.
Yeah, I knew you'd represented them, so I knew you'd have a good explanation.
Were you a new staffer?
No, no, no.
All right, what's your pleasure?
There was no opposition. I move favorable.
Motion for a favorable has been seconded. Senator James?
Senator West, I guess I don't want to make it bigger than it is, but this is such an odd history, isn't it?
It is.
My dad was
Yes, it is.
Episcopalian.
Yeah.
So rather than the state getting completely out of the Church of England,
Right.
they don't want to do that. They want us to continue to
We know how it works.
make statutory changes.
You know how it worked. The Church of England was a split off from the Roman Catholic Church,
Kind of kidding.
and the Episcopal Church is a split off from the Church of England.
I know, I'm just kind of kidding. Okay, I'm just saying the Episcopal Church.
Yeah.
Doesn't want to ask us to just get out of the business of having to legislate for them. They prefer us to continue.
That's right. Yeah,
to Do that.
exactly.
That's interesting. That's so, I'm just really.
And-
surprised that we didn't do
I absolutely don't know. Of the Washington DC diocese.
That's why you're fabulous on.
So the codified provisions that are being added by the bill mirror similar provisions that are already in the Corporations Association's article for the Roman Catholic Church, the Methodist Church, the Presbyterian Church, and the Episcopal Diocese of Maryland and Easton. So it's creating the same statutory framework in the code. And I think part of the concern was, since it wasn't in the code, SSTAT wasn't technically able to register these as corporations. So that was, right, that's the main reason that it should be in the code, as the advocates argue.
I'd like to add Anthony's Church.
It's a motion for a second. It's been it's motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 429 passes unanimously.
Had the Jews. Had the Quakers.
All right. We're gonna hold Senate Bill 470. We're gonna hold 452 until Senator Carter gets back from her bill hearing. Let's go on to, Josh, can you ready to explain just in concept for Senate Bill 468? We don't have the amendments before, so we'll get to it on Tuesday, but I just want to make sure people are kind of briefed on what we're thinking.
So Senate Bill 468 as drafted alters existing notification requirements for private home detention monitoring agencies to require them to make specified notifications immediately rather than on the next business day as is under current law. So some amendments that are under consideration would, instead of this notice provision triggering when an individual has been missing for 24 hours, it would be when the individual has violated a term of pretrial release, which was a suggestion of the judiciary. And instead of requiring an immediate notification, it would require notice within 12 hours. The amendments would also remove from the bill provisions relating to reestablishing the work group on home detention monitoring. And there's also discussion of potentially altering the timeframe for the required notice depending on which crime the defendant has been charged with. So perhaps requiring a quicker notification for someone who's been charged with a crime of violence, and potentially adding some civil penalties for private home detention monitoring agencies who fail to make the required notice.
So those last two ideas were kind of borrowed from the Indiana statute, which we can distribute to, let's make sure everyone has that on Tuesday or Monday. And then we'll have to have discussion as whether, what type of fines we could levy if they fail to notify within the time limit that we prescribed, and what type of impact, if any, that would have on these 5 companies that operate in Maryland staying in the marketplace. So we should discuss that. Right now, if I were to ask someone on this committee, what is the current time frame? Who knows? So you had to be missing for 24 hours and had to notify within 24 hours. It's like 48 hours. On the next business day. So it's like, it could be up to 48 hours. Which is the problem. So we're trying to decrease it to 12 hours. And then maybe more immediately for crimes if the person is, on supervision for a crime of violence. Okay, so you'll get the Indiana statute, you'll get some draft language on Monday or Tuesday, and then we'll revisit this on Tuesday. But just so everyone has an idea. Okay, and then the other thing, the task force is being stripped out of this bill because we have another bill that has the task force. You can do that one right now, yeah.
So Senate Bill 1095 reestablishes the work group on home detention monitoring to study and make recommendations regarding the cost and availability of public and privately provided pretrial home detention monitoring systems.
All right, so we're going to move those two bills together on Tuesday once we have a chance to discuss. So that they're funded through FY 25. Is that right?
I think that's
okay. All right. So we're holding 470. 471 is being held as well because of BNT. We need BNT approval. Senator Folden, do you want to go? We can talk about. Let's talk about the amendments that were discussed for Senate Bill 479.
So Senate Bill 479 makes changes to the state's work zone speed control system program. A work group met and discussed a number of changes to the bill, and I don't have my materials right in front of me, Senator Fulton. So if I forget anything that you remember, feel free to jump in. But some of the ideas discussed by the work group would be to require additional signage in entering and exiting a work zone, to require things like flashing lights when the work zone is active and workers are present, to give some more direction to the Department of Transportation in the way that they spend funds which come into the Transportation Trust Fund as a result of violations recorded by these cameras. And in terms of the penalties for violations, similar to a school zone, there was talk about doubling fines when the work zone is active and workers are present, and potentially setting up a sliding scale of fines based on how far above the speed limit that an individual was traveling when they were recorded. And I think there was also discussion of equipping the systems themselves with some kind of flashing lights so that people saw them and were aware that they were there.
Wait then. Thank you. Yeah, I mean, that's a really good overview. The important components of that were realigning the fee schedule to be consistent, similar to like school zones, like you said. The notification being at the entrance that it would be flashing lights when there are actually boots on the ground, and at those times it would be posted that fines would double like school zones. At all other times, when the lights are not active, when there's no boots on the ground, it would be a straight fee schedule based on how fast you were above the posted speed limit in a graduated scale. And that was an important element as well. And then also there was discussion about the lighting atop where the cameras are actually located, that they would be blue so that it would be an actual indicator for people to slow down as they're entering the zone and see, because blue lights do contribute to the slowing of people, or should. And then we had talked about one other component that we hadn't got done yet, but that's the basis of the amendment. The other component is for where the money, how the money is aligned. Yeah, that's it. Yeah.
Can I just? Did you all discuss, wasn't there a local component to this, but, was that touched at all? Is that being looked at all? I know it was just enabling, right? The local.
Yeah, and
And then for once, the new thing would be, it wasn't the bill that they could then get the money themselves directly as opposed to what's happening now. Is that?
yeah, and I believe the House in their amendments that they moved, they did include a provision that the locals could keep some of the revenues from the system that they set up. So I think that has been kind of the roadblock for them and setting systems up, is that the money under current law goes to the state.
Well,
Well, it goes to transportation. Where's it go?
so that was part of the issue, is that when they came in, they made a very profound point that it was no longer about safety by having these things there. It was about that they weren't getting any of the monies. So that was a discussion that we had. I know we've talked about even figuring out a way to make a reasonable guidance if we were to adopt something like that. But that was one of the issues that they said, well, why would we do that and set it up? Because we're not getting the money. And that takes away from everything we're talking
I don't
about.
want it to be about the money, I want it to be about
Correct.
safety, and I do understand giving the locals money to cover their costs for sure, anything like that, it should be cost neutral to them, but.
Right.
To the extent it becomes, we'll do it if we can make some money off of it versus safety, I think that's a.
Yeah.
Little,
Agreed.
so that's just still being discussed.
And that's a
right now.
discussion that we still had. I mean, we did discuss that, but I think we went off on the more larger portions, and now we're down to basically where the funding, how it's aligned.
Yeah.
Fair, Josh? But this amendment is, were you looking to move this amendment as it is, Mr. Chair?
I mean, that's up to the committee. I mean, I like the amendments, but I wanted to make sure we flushed out.
Well, we can adopt this amendment.
Okay, just in terms of drafting, we're not done yet, but I like all the content. I like the content.
It's fine.
So we just do it all on when we're ready on Monday or Tuesday?
Tuesday.
Yeah, Tuesday, when we vote again. But anyway, so we still need to figure out the funding, the money piece, and then we'll get back. Okay. All right, so that's held, but at least everyone is briefed.
Senate Bill 518 extends the termination date of Chapter 654 of 2022, which established a task force on property appraisal and valuation equity from June 30th, 2024 to December 31st, 2024. The bill also extends the date by which the required report is to be submitted from October 31st, 2023 to October 31st, 2024. The bill takes effect June 1st, 2024.
Motion for favorable, it's been seconded. Is everyone okay with being recorded in the affirmative for Senate Bill 155? Or sorry, no, 518, sorry. 518, is everyone okay with that? All right. All right, we're gonna hold Senate Bill 538, but I'd like to have some folks work on it.
Just tell me.
Yeah, I'll sign a work group afterwards, okay? If I do it on camera, you're gonna be blown up over the weekend. I'm kidding. Kidding. Yeah. All right, Shamari, what do we look like with 550 here?
550. Senate Bill 550 adds labor trafficking by a child's parent or guardian to the list of conditions under which a local Department of Social Services is authorized to ask the juvenile court in a child in need of assistance proceeding to find that reasonable efforts to reunify a child with the child's parent or guardian are not required, and to expand statutory provisions related to the Safe Harbor Regional Navigator Grant Program to apply to child victims of labor trafficking. And so there is an amendment in your packet. That amendment adds labor trafficking by any individual to the definition of abuse to align the definition with sex trafficking, which could trigger Child Protective Services investigations. The House is considering another amendment that would delete provisions from the bill. So if you look on page page 7, line 7, that's 3-812. The House amendment would delete that entire section from modification by the bill. The justification behind that is that 312 deals with the circumstances under which the local department would ask the court to find that reasonable efforts to reunify a child with the child's parent or guardian are not required. And the reasoning was that this really deals with very serious offenses. Not that labor trafficking isn't one of those, but it deals with torture of a child, chronic and life-threatening neglect, sex abuse, and that's it. So that's the amendment the House is considering. I think the sponsor was considering adopting the House amendments. And so it's, I guess, up to you all.
No, I spoke with counsel, so I know that there are portions of Amendment 2 that they were going to make modifications to their bill, and there were some portions of theirs that council was going to make modifications to this amendment. So and I think he spoke to the things that aren't in here that he was talking about bringing over from the House version.
The labor trafficking definition under abuse in the House version just says labor trafficking. It does not say labor trafficking by any individual. And that was DHS's concern that that definition should align with sex trafficking by any individual so as not to shield potential malfeasors.
Let's do, we're just gonna hold this until the next time we vote. We'll consult with the senator, the department, Melanie is back here to help. And we'll just get it tightened up and move forward. Any other questions from anyone? It sounds, yeah, we'll work on it. We'll get it right back up on the list.
Amendments to conform, the intent of the two are the same, making sure that the language is aligned to that. Really
Boss it over. Did the House already adopt their amendments?
No.
Did the House already adopt those amendments, or they're both being considered in flux? Got it.
I held up amendments, so making sure that the two conform. I think we're different.
Can you just talk to the House sponsor over the weekend and we'll all figure it out? We'll move together. Okay. Excellent. Thank you very much. All right, so that's held. Huh? All right, so now we're going to go on to Senate Bill 630.
Senate Bill 630 prohibits the creation of a lien on owner-occupied residential property by contract or as a result of a breach of contract for the payment of medical debt. Medical debt means debt incurred due to a medication, procedure, service, or treatment that a medical professional determines to be medically necessary. However, it does not include cosmetic procedures or services, or a medication procedure, service or treatment that a medical professional has not yet determined to be medically necessary. So there is an amendment in your packet from the sponsor, and that amendment conforms to the House cross file, and it deletes the portion that deals with cosmetic procedures or medication procedure, service, treatment that a medical professional has not determined to be medically necessary.
Let me just clarify the amendment. It's not actually deleting that part. It's just clarifying the language, moving the language that still requires it be medically necessary to conform it with the other parts of the code where, so the definition is just going to be consistent. We're not removing that. Cosmetic procedures won't be covered under this. But I do want to hold the bill because I know Senator West missed the hearing and he has some questions for Heather Forsyth with the HEAU, correct? So we can bring that up on Tuesday's voting list. Give him some time.
Yeah, I don't think this bill works as written, or as written, it doesn't do anything. So I want to change the bill so it actually would be in some way effective to deter conduct or regulate conduct. So the bill is written to a section of the law that deals with contracts that are recorded in the land records. And I'm not aware of any contract for medical debt which is ever recorded in the land records. So I don't think this bill would accomplish anything as written. And I'd like to work with the sponsor to rewrite it in a way that it would accomplish something before Tuesday.
Yeah, and I'm happy to work on amendments if they're necessary, but I think the first step is to make sure that Senator West can talk to the HEAU and Heather Forsyth because she has a different opinion. So I don't want to misrepresent that. So let's make sure we're on the same page and see if there's a need to change it. And if so, we will do so.
Have a clarification question. I just want to make sure that cosmetic procedures are defined because there are certainly, burn victims. There's a lot of, you could be beaten up. There's a lot of that, it's not life or death. I don't know if it's medically necessary, but if you've been hurt like that, then
yeah, there are quite a number of procedures that might be categorized under certain circumstances as cosmetic, but are medically necessary. Breast reconstruction, for example, after cancer, those types of things. So those would be covered. Debt incurred from those types of procedures would be covered as medically necessary. What would not be covered would be voluntary cosmetic procedures.
Well, but you don't need necessarily to improve your looks after you've been brutally beaten up. You could just heal.
Right, so the medically
want
necessary is a definition that we use as determined by a clinician. So if the clinician determines it's medically necessary, then that would be covered under the that's how it works with the hospitals. We're using the exact same language for medically necessary that we already have in the debt medical debt law around hospital care. This is just extending it to out of hospital care. So we want the system to work.
I do understand medically necessary, that term. And all I was trying to clarify, and if you're telling me don't worry about it, I won't. But I just want to make sure that cosmetic procedures that I don't know if medically necessary. Let me ask it this way. Did you learn that routinely, let's say that there was, you were beaten up and, really had your jaw broken, that all got fixed, but you also had some other deformation of your face, let's say, as a result of being beaten up. Now you could just heal and you'll be fine. It's not life threatening or in any way impairing you, but you do look bad afterwards. So do doctors routinely say that would be medically necessary? Is that what they normally do?
Yes.
Okay. All right. Thanks. Good.
Excellent. So we'll hold it until Tuesday. All right, great. All right, we'll now move on to Senate Bill, this is Josh, Senate Bill 652.
Senate Bill 652 requires the Department of Juvenile Services to report to the General Assembly by December 1st each year on the number of juveniles under the department's supervision in the preceding year who were non-fatally shot another individual, or were victims of a homicide, the actions that the department took in response to such incidents, the age of each juvenile in the report, and the county of residence of each juvenile in the report.
It's your pleasure. Senator Carter.
Didn't we have some language?
It's more
To this and the other bill, and how, this may go a little further, but
Squinting, but not as far as this.
And that,
Could roll this into that.
I think that the commission also has to collect similar data. The
I'm just
commission
saying,
on,
like, doesn't it, is there any possibility it's a little redundant? Like, can we just put it in there?
We could roll it into the bill.
Whatever you're.
All right. So do you want to amend, can we put it so that it goes into this newly created commission as well? What's the name of the commission again? It's called the Best Practices and
so it's the Commission on Juvenile Justice Reform and Emerging and Best Practices. So I think if you wanted to amend them to be included on this report, it would be on page 1 of the bill. So in line 18, the department shall report to the Commission on Juvenile Justice Reform and Emerging and Best Practices,
roll it in.
and in accordance with 21257 of the State Government Article of the General Assembly. So just adding the commission there. They would also receive the report from DJS.
So we'll do the report, but they'll get the report.
Alright.
Sounds good to me.
All right, so is it okay, is everyone okay, is everyone okay with, let's adopt that amendment first, is it okay with, is it, okay? All right. All right, Senator Sidnor seconds it. It's now the bill's before you with the amendment. Do we need a roll call or do we need, is everyone okay being recorded in the affirmative? This is. It's a report. It's a 652. And what we've done is we've amended it so that it reports to the Juvenile Justice Committee on emerging and best practices and as well as the General Assembly. Is everyone okay being recorded in the affirmative? All right, Senate Bill 652 with amendment passes unanimously. All right, now we're gonna go on to Senate Bill 858.
Yeah, so so Senate Bill 858 authorizes a person or the Attorney General to bring a civil action for the non-consensual distribution of a visual representation, including what's termed as a deep fake of the person with the person's intimate parts exposed or while the person is engaged in sexual activity under specified circumstances. Public inspection of court records in applicable cases is restricted. Also as specified, by December 1st each year, the Administrative Office of the Courts must report to the General Assembly on the number of civil actions brought under the bill. The bill contains a severability provision and takes effect July 1st, 2024. There is one amendment in your voting packet, and I'll note that with the amendment, The bill deals with both criminal and civil aspects of the law, and Mr. Taylor and I were working concurrently on this. So I can probably speak better to the criminal aspects of it, and I may defer to his expertise on some of the civil aspects. But the amendment in your voting packet is 723-123/1. The amendment strikes provisions of the bill and provides that a person may bring suit for defamation per se under certain circumstances in which another person distributes a computer-generated visual representation that is indistinguishable from an actual visual representation of the person and falsely depicts the person with his or her intimate parts exposed or engaged in sexual activity. The amendment also alters the state's existing revenge pornography statute to include computer-generated visual representations and alters the elements of an offense under that section of law. I would note that it's not in your voting packet, but before the voting session yesterday evening, we received a request from the sponsor. Senator Hester's office asked that the bill include language that a prevailing plaintiff could recover attorney's fees for the defamation per se suit.
Do we do that in other?
Yeah.
I'm on the bill and I think the bill is super important, but as is just to be consistent, I generally do not support the awarding of attorney's fees, regardless of the side. But and I'd be willing to really talk to the sponsor because I told her how much I like the bill, but we could offer and make it explicit, perhaps that you could recover punitive damages or treble damage or something like that. But it's a slippery slope going down awarding attorney's fees. So I just throw that out there if they are worried that somebody was harmed, and I get it. And then you're out there trying to, protect yourself and hold somebody accountable. It's a daunting thing and you have to hire a lawyer. And then they get a share of what you recover, and maybe don't recover that much. But so I just am hesitant on the attorney's fees, but I'm very open to other ways that we could help the sponsor with that idea. Or not.
I'd like to get a couple of us together on Monday or Tuesday to work at this. Okay. Yeah. We can bring the sponsor in as well, but we'll get it. Okay. Jamie, this is you as well, right? Senate Bill 905.
Yeah. Senate Bill 905 authorizes researchers affiliated with institutions of higher education who are conducting academic or policy research to review a court record related to a petition for an extreme risk protective order. There are no amendments in your voting packet.
Senator Kelly.
Just to refresh the members of the committee, there's no opposition to this bill. It's really just for research. It has been happening temporarily under legislation that we passed a few years ago. And this is similar to how it is structured in most of the other states. There was a letter in the file from the judiciary just asking for clarification on privacy protection. So I will also remind the committee that you heard during the hearing that there are existing federal laws around the privacy protections. So just wanted to note that. I see we have some questions.
What are we? The privacy protects that are concerned, are we talking about only the ones that were served or the ones that were recalled or all of them? I mean, this is just such a broad thing, and you're getting into people's personal information, and you're also getting into requests that under law, there's only a certain amount of people that can ask for these ERPOs. So are we only redacting their information? Are we redacting the suspect's information? And are they able to see it before it's redacted? I just have a lot of questions about this.
Understand it the way that it works well in other states. We're not redacting the information. The researchers are depending on the federal rules for in their research. They're not sharing information. So I can read to you specifically
No,
from.
That's
No, you
okay.
don't
That's
need to.
what I
Okay.
thought. I mean,
So we're not asking the judiciary to redact anything. What we are is depending on the federal guidelines. For
and that where is
privacy
where
protections.
my problem lay, is that we have these ERPOs, which are issued by sometimes by people that feel a certain way, threaten, and this is, and then if we have that and now they're going to go and they have this information out there, that's a private issue. That's not something that's out there for the public in general to see, is it?
No, it's all aggregated data that is then used by the researchers for their work.
Yeah. Well, that's provided. Yeah, but all the information is going to people in academia that are able to see all this private privileged information and the circumstances around it. And I mean, I
The
don't.
researchers would have access. Yes, that's your point.
Yeah, I mean, they're not that. I mean, you're talking about people that just paid to go to school that have now access to this very.
Well, they do have, there's federal guidelines that they have to submit approval for their research. In order to do that, they have to set up protocols that comply with the federal guidelines. They're held to terms set forth by these guidelines for their approved research. So there are confidentiality protections in place in all of the other states that are doing this as
I
well.
understand that, but my concern is that we're doing this for these certain type of orders. Where are we going to start having research that has identifying information that's not redacted out there for, I don't know, what would normally be protected for, the juveniles that we're picking up for different violations. And as long as it's not put out outside this body that, we're going to start having that out there for repeat violent offenders of juveniles, that we're going to start tracking that. We're not, because they're going to be protected. But these people, it's also, this is a private court document. And we are now putting that out into what, I understand there's federal guidelines, but there's also people that just take a pictures of stuff and they keep it for later use or something off of something that it may not even be substantive. It may not have been anything other than someone's emotional response to something that they went and got an ERPO. The person goes and gets their hearing a few days later and the judge says, no, it's not warranted. And this information is still going to be out there.
Just to shepherd this on, I think you make some very good points. I mean, very, very good points. So I think what we can do, because I love this bill, but you make some very good points. And so for the institutional review boards, we're going to pull what the composition looks like. We're going to pull the regulations, who's on the review boards, what are the regulations, are there penalties for disclosure? Because a lot of these things are probably not going to be redacted when they come back from the courts, but it's within the confines of an institutional academic setting that's been used for research. So let's just pull
There's a lot of questions about it, and I appreciate that.
Yeah.
I just mean, like, why can't we put in there that the specific names would be redacted as a requirement?
I think that it's going to be a fiscal thing, but it has no relevance to their research. That's true. That's very true.
So,
but let's at least figure out what the regs say.
Okay.
And maybe there's something that will satify and meet that.
So we can hold it.
Yeah, we're gonna hold it. But
Thanks.
Absolutely.
I love this bill, but I think you bring up some very good points.
Thank you.
Okay. And so we're gonna get, so for council, just the do outs, just understanding who sits on the boards, what the regs look like, what else, what you think would be relevant. Can you put Jamie on, please?
So I'll go ahead and reach out to Hopkins and University of Maryland, who came in and provided testimony on the bill. And
Yeah.
right,
Yeah.
so just an explanation of the institutional review board's process. We'll also do the protocols for handling confidentiality that they would be using in these situations, and also specifically what regulations they're referencing. I'm just not familiar myself with what regulations they'd be referencing under the federal regulations. So just getting clarity on those three things.
Excellent. Okay, that sounds good. All right, so now we'll move on. We got we're gonna move on to Senate Bill Josh, just an explanation of 1095. We're gonna hold that until we get the other home detention monitoring bill queued up for Tuesday. But just if you could provide a brief explanation, it's pretty straightforward, but.
Yeah, I mean, Senate Bill 1095 reestablishes the work group on home detention monitoring to study and make recommendations regarding the cost and availability of publicly and privately provided pretrial home detention monitoring systems.
One subject of debate always with this group is whether there should be representation from these monitoring groups on this board or not. So just be thinking about what you think about that before we come back on Tuesday.
We're gonna give them the current status.
Yeah, go ahead. You want to give the current status?
Oh, I mean, did you want, as drafted?
They're in,
But not voting.
they're non-voting. Yeah, that's right. Yeah, they're two non-voting members. That's right.
Be brought in for informational purposes if they're not gonna vote, and it doesn't matter to me one way or the other if they're not voting, but just wondering.
Yeah.
They don't need to be a part of it. We'll make them feel good. But since we could change and they might not be the ones that are there in perpetuity, they could lose a contract. Is this gonna look into the more transparency into the awarding of these contracts? Okay.
Corrections runs that process. It's kind of a mess. Okay, not kind of, it is a mess. All right, Jamie, can you go on to Senate Bill 1097? Just a brief explanation. We're not going to move it today, but just want to an explanation of the amendments.
Sure.
So that folks can think about it over the weekend.
So the Senate Bill 1097 requires, as drafted, it requires a person or entity operating a gun buyback program to destroy a firearm, including every component and part attached to the firearm that is traded in at a gun buyback program. Destruction must take place or must make the firearm and every component and part attached to the firearm permanently inoperable and unrepairable. A person or entity may contract with a law enforcement agency, an organization, or a business to satisfy the firearm destruction requirement. Violators are subject to a maximum fine of $10,000 per violation. If a violator is a licensed firearm dealer, in addition to the fine, per violation, the Secretary of State Police must revoke the dealer's license. There is one amendment in your voting packet. It is Amendment 583727/1. The amendment does a couple of things. First, it amends the bill to include various provisions relating to firearm safety, crimes, and licensure. Second, it adds provisions requiring licensure of qualified handgun instructors by the Department of State Police and requires that certain license applicants take a one-time multiple choice exam relating to their knowledge and application of the topics required to be taught in a handgun safety training course. These provisions do not go into effect until July 1st, 2027. The remainder of the bill
Just before we go on, to just explain it. So a lot of these were done in consultation with the Maryland State Police and some of the folks that came and testified for the enhanced requirements for to become a licensed instructor in Maryland, which is now we're kind of setting up this process.
Sure.
Can you just talk about why the delayed effective date and also if this does it for HQL as well or just for
So, right, I guess some of the feedback from folks in the that work on the issue had been that the requirements for training that the General Assembly had passed last year had really only just gone into effect in October. So that was less than 6 months ago. And their suggestion would be to make it so that there's time to sort of see how that goes, and for people to get adjusted to the new process. I think it was more in the context of that was the direction that the committee should go, but this is just how the amendment ended up drafting.
Thanks, thank you.
Sure. So the other provisions of the bill go into effect October 1st, 2024. Those provisions would be an exemption for DNR employees carrying out official duties from provisions of the restrictions on wearing and carrying in sensitive locations, which were established under SB 1 last year.
So can you just give the background of the SB 1? We forgot, but it's kind of an oversight.
SB 1 had several exemptions for wearing, carrying, or transporting a firearm in locations that were sensitive locations under the bill. There were law enforcement officers, for example, are generally exempted. But DNR advised that they have employees which I believe are involved in animal control activities who are not sworn law enforcement officers, but would still need the use of firearms in those locations potentially. So if there were a wild animal that got into a sensitive location, they would want to be able to bring in a firearm. So moving on, the remaining provisions of the amendment classify theft of a firearm as a 5-year felony. The amendment also alters the gun buyback provisions to apply 1097.
It's a little bit of a Christmas tree right now. Yeah.
It alters gun buyback provisions under the existing bill to apply to FFLs and law enforcement agencies, and makes various other changes to the buyback language in the bill. It classifies trafficking of a regulated firearm as a felony. And as I noted, those provisions go into effect October 1st, 2024. I'd also just like to note that the amendment that you have in front of you, I noticed a typo in it. The title would need to be updated to reflect some of the changes that are happening in the bill. And I'll leave it to the chairman.
So we're not going to vote on it now, but just so you have the idea what the amendments do. Senator Fulton.
Thank you. So so we don't have any input from anybody on the amendments, right? Except for here, like I don't know how it came up. But that's my one concern. And I gotta say, so some of these organizations like Everytown, Moms Demand Action, the Brady, are they also they're recognized firearms organizations, right? Whether they're pro-gun or against is irrelevant. They're recognized. So they have their own training. Does their gun safety training, will that count towards this? So none of theirs will count towards it, or some of it would count towards it?
Are you talking about for the instruction piece?
Yes.
So as far as state police did advise just some background information on how the process currently works. My understanding from talking with MSP is that only the NRA course and the USCCA courses are currently recognized.
Okay.
But I can follow up over the weekend with them as
and
well,
then
but I think that's right.
I appreciate it. Thank you, Jamie. And then I would like to point out, when I was reading back through the testimony, there's one that stands out to me from Glenn Muhammad, and he's the state director for the National African American Gun Association. And Galen makes the comment, and I think it's very important that if nobody read that, that he points out that it's been proven time and time again that gun buybacks simply do not work or decrease crimes or suicides. They're turned in, that the guns that are turned in are generally not guns that have been used in crimes, obviously, because people that are using guns in crimes aren't turning them in.
I thought that just not to, I thought that was all great, but this doesn't say you should do gun buybacks or you shouldn't. It just says if you do, then you have to do them like this. And so,
well, but this is what in his, it goes on again, and he continues to say that these buybacks, you know, you've got a lot of these printed out lowers and they make them for like pennies on the dollar and they're getting $25 or $50 back per lower. And it's just printed out on a 3D printer. And then you've got, again, he makes reference to the criminals not turning in their guns, but then he makes the comment about these gun buyback programs are targeted in Black and brown communities all over Maryland, around the country. These programs are never set up in other communities where few Black or brown families live. This bill is strictly for show. No crimes or suicides will be prevented by it becoming law. So as a part of this, are you requiring them then to also have these gun buybacks in predominantly white communities?
like I said, this doesn't incentivize or disincentivize gun buybacks. It just says if you engage in this activity, this is how you have to do it. So all that doesn't go to, maybe no one ever does a gun buyback in Maryland ever again. That's fine by me. I don't care.
But what I'm saying is,
Yeah.
are we requiring as a
No.
part of this,
No.
to his point, to say that they have to do them in both, not only, you know, high crime areas predominantly of Black and brown people, but they have to be done proportionally, like we've always tried to legislate, also in white communities, predominantly white.
That's a different bill. If he wants to come and bring that bill, he can do that. I mean, this has nothing to do with that. I mean, this is literally just like, if you engage in this activity, you just got to destroy the weapons completely, so they're not recirculated into the ghost gun market. And
Well, I think it is relevant to this because we're talking about if you set them up. So we should be talking about where they're setting them up. If they're, you know, that it's got to
Yeah.
be proportionate to the.
I'm happy to have a hearing on that one. I mean, I do that. I mean, if you, but not on this bill.
Mhm. Okay.
Senator James.
I just would like a little background. So we're adding potentially this very different aspect of gun issues, which is about licensure. So does the Maryland State Police already license firearm weigh in or on firearm training courses and the license for those that can teach it? Doesn't that happen now?
There's a little bit of a complicated answer to that.
I thought so. That's why I'm
Um,
confused. I'm confused.
State law itself is fairly limited, or at least in statute, is fairly limited on what it actually says about qualified handgun instructors.
Instructors.
The law requiring training for wear carry permits and for handgun qualification licenses generally says, and I'm paraphrasing here, that it needs to be a course approved by the secretary, taught by somebody who is a qualified handgun instructor.
Right.
That's really what is a qualified handgun instructor is limited to basically some definitional language that we have in 5101 of the public safety article.
Okay.
And it says there's 3 ways that you can become a qualified handgun instructor. The first is if you are recognized by the Maryland Police and Correctional Training Commissions. The second is if you are licensed by the state police. And the third is if you are instructor who's completed your certification course through a nationally recognized program. Historically, that's been the NRA, and I think more recently has been USCCA also has a training program. From there, in talking with state police about how it works in practice, regulations sort of fill in some of the gaps here, but in practice, in order to teach the course, so say for example, somebody's certified by the NRA, they would evidently not be able to just begin offering training courses. They, under current practice, are required to submit registration, I guess is the word that I would use for it, but basically submit the paperwork that they have showing that they qualify under that definitional language
One of these
as being a qualified handgun instructor. And then state police will send them a certificate that shows that they are a qualified handgun instructor. It gives them a number that they can use when they're verifying the fact to state police that somebody who comes to state police seeking a handgun permit, for example, actually did take and pass the course through that specific instructor. So there is a relationship already with state police.
Okay.
It's but you know, I sort of say that with it's not well defined in statute. I think regulation and practice sort of fill in the gaps there.
So is it possible under this, we didn't have a hearing that I can recall on it, so I don't know what the state police or others would say, nor do I know what current instructors would say. I don't even know if they have an association or something, but I get, we certainly want a good quality instructors, but I also don't want to ensnare people in a situation where they've been teaching for a long time and, you know, seem to be doing a good job. And suddenly what they've been doing isn't going to satisfy a brand new statute, and then push everybody to run and do something and make, you know, kind of just blow up the system as it currently works without some consideration of what these people have been doing. So again, without a hearing, I don't even know how to ask the right question, but that's sort of where I'm trying to figure this all out.
Thank you, Mr. Chair. Senator James. So yes, this is coming from, this language is coming from those qualified instructors already. So that's hopefully will show that no. Because I'm the one that brought this amendment in and asked for it to be put here. Second of all, one of the things is we're having a little bit of an issue that let's say you want to be a qualified instructor in Maryland to teach, but you're in Pennsylvania. You come down, put a 2-day class for at the Holiday Inn. Now I've just taught all these instructors, and there's never been a real clear list of what actually has to be taught. So instead of saying 2 days, make it 5 days, you actually have to put it in and say some kind of structure to make it work. Yes.
The quality instructors that we have in Maryland are saying, look, we think that we can improve the training and the quality of our instructors by having some clear requirements and uniformity and hopefully best practices. Is that what you're saying?
At the end of the day, better education is better for the recipient who's going to eventually get their carry conceal. And so if it can be taught in 2 days or it can be done in 40 hours of instruction,
Yeah.
40 hours is much more, but we have to lay out and say exactly what that's going to be.
I just don't want to get irate calls
I don't believe
from
you.
instructors or businesses who say, you didn't talk to us, you're doing this without any
So I
weighing
will-
in or any hearing,
Right.
and whatever
So
else they
I
might
will-
say.
I will have them reach out to you.
That'd be great.
To clear that up for you. But
I've gotten to know a few being on this committee
absolutely,
now. All
absolutely.
right, thank you. Thank you.
So, thank you, Mr. Chair. Sorry to go down this path, but you know, I guess 2 questions. One is if by enacting this, do our current certified instructors automatically become non-certified?
Right. So as it's written, there's no grandfather provision in there. So they would need to come into compliance.
3,200.
Well, right. So just a little bit of background on the bill, and just so you know, there's on the amendment. So there's the way that it's drafted. The chairman's amendment pushes out the effective date a couple of years. So it would be July 1st of 27 when the requirement starts. As far as compliance, it does retain generally those three categories of folks who are currently eligible to be qualified instructors, but it adds this additional layer of the multiple choice exam.
So I appreciate that. So I just be clear and on the record, like instructors have the thing instructors are asking for isn't necessarily the longer drawn out class. What they're asking for is delineated, clearly defined, subject specific areas and things that they are required by law to be covered. And MSP is providing zero guidance on that. So you can have somebody that goes through a firearms instructor through, you know, the NRA, you can have somebody that goes to a firearms instructor through another organization. And as long as they submit and attach all those files and say, hey, this is what we did, there is no standard that requires them to cover different constitutional law around firearms or around SB1. There's nothing that requires it. So why are we putting more onus? Okay, why don't we make it 100 hours? The point being is if there's no clear direction given and guidance by the leading law enforcement expert in this, because they're the certification authority, we're not making any progress. We're just adding 3 more days or 2 more days to the training, and we have zero guidance. And you're gonna, if I go to your class, your block of instruction is going to be different than if I go to his class, and his is going to be different than I go to his. There's no clear guidance. So the standards are what is so important when it comes to gun laws. The standard and the application of those standards, the training must be consistent. You should be able to go from one person's firearm instruction to the next person's to the next person, and the blocks of instructions should be in lockstep.
Couldn't agree more on that. So let's put it, I mean, I 100% agree. So, and I think that's the goal for everyone here, but
We didn't want to put
like an hour.
But we
limit
don't
on
have it.
Yeah. So we'll continue working on it. So look, if we can figure this out this year, we'll put it on this thing as an amendment. If not, we'll have another, we'll just come back next year and we'll do it with a bit more fleshed out idea. So. Yeah. All right. We're working it. All right. Senator Carter, then Senator West.
Thanks, Mr. Chair. My question goes to that as well. And senators, you might be interested to know to speak about the lack of uniformity and how there's no set thing. I've actually participated as an instructor in a training course several times in my life, even prior to becoming licensed myself, just educating about the Maryland laws on guns. So my question is, in the new or additional requirements for the training, has there been any assessment or estimate done of what the difference in cost would be for the person to go through the training?
So, and just to be clear, were we talking about
It's for the instructor.
For the instructor. So, in the amendment language, currently MSP, and again, for lack of a better term, I'll use registers the instructors at evidently no cost. Currently, they don't charge a fee to the instructors. That doesn't change with the relationship between the instructors and MSP under the amendment. What the amendment does authorize is the use of third-party testing centers to administer the multiple choice test. So that would be a supervised exam, and it doesn't set a specific fee. It does allow the testing centers to charge a reasonable fee for administering the exam. We don't have an idea at this point, or at least I don't have an idea at this point as to what.
No, so that answers my question. I just wanted to ensure that by putting these additional requirements on the training of the instructor, we weren't putting people in a position where they were excluded from being able to become instructors because of a higher cost.
All right, so if we figure this out, we can figure it out. If not, then no worries. We'll strip it off the bill. Senator West.
Question was, we have a couple of people who frequently appear before us, Mark Pennick, John Jocelyn. Have we even consulted them? And okay, so long as they sign off on this, I'm fine.
All right, so we'll continue working on it. But that's, now you got a preview of what the amendment looks like. So we'll revisit the bill on Tuesday. All right. Which one is that? We're about, we don't have a letter for that apparently.
So, West, Mark hasn't gotten back to me yet, but he does.
Do we have a letter for it?
So I'm waiting to get back.
I didn't see it yesterday.
Do we have a letter for it? Who do they send it to? All right. It's the last bill of the day right here. Senate Bill 452.
Senate Bill 452. Senate 452 establishes that any provision in a contract or agreement relating to the use of a recreational facility that purports to limit the recreational facility's liability or release the recreational facility from or indemnify or hold harmless the recreational facility against liability for injury caused by or resulting from the negligence or wrongful act of the recreational facility or its agents or employees is against public policy and is void or unenforceable. There are two amendments on in your packets. The first amendments would exempt a lodging establishment as defined in 15201 of the business regulation article. Lodging establishment is defined as an inn, hotel, motel, or other establishment that has at least 4 rooms available for a fee to transient guests for lodging or sleeping purposes. And the other amendment would exempt health club services agreements under 14-12B-01 of the commercial law article. And there, I just received.
Hold on. Shamari, please finish.
There was an additional amendment that was just sent to me during the voting session that would limit the prohibition in the bill to just agreements between adults, and so it would still be applicable to children at recreational facilities. You don't have that in your packet though.
Let's talk about this. So they're actually stapled together, but let's go amendment by amendment, discuss, and then we'll see where things go. No. I'm here. We're doing this. All right. So Shamari, you do the First Amendment first.
So the First Amendment 503527/1 that would exempt a lodging establishment.
Thank you. And this is amendment that I am suggesting, and I've spoken with the sponsor. I know she would prefer we not adopt it. But I actually was contacted, I'm a co-sponsor on this bill. I support this bill. But when I understood that I was supporting the bill, I did not think that it would apply to hotels. That's not how it was described to me or presented at the hearing. Marriott, which is in my district, did reach out to me because they thought there's a possibility it might apply to hotels, and they sought guidance from the Attorney General, and the Attorney General concurred. So the language was kind of vague in the bill, but the Attorney General thinks it could be interpreted to apply to hotels. So this amendment would make it clear that it does not apply to the hotels, and my hope is that we would adopt that.
Thank you.
All right, do you understand the amendment before you? So Shamari, anything else?
So the.
No,
other-
just on this, on this
Oh,
amendment.
just
on
that
this
amendment.
Yeah, yeah.
So
So I think, okay. All right, let's just, okay, so everyone, well, so no, 2 no's, 3 no's. Let's do roll call.
Vice Chair Waldstreicher,
Yes on the amendment.
Senator Sidnor,
No.
Senator West,
Yes.
Senator Muse,
I want my sister Jill, no.
Senator Folden,
Can you second my move?
Yeah.
Yes,
Move it along.
yes.
Senator James,
Yes.
Senator Charles,
No.
Senator Kelly,
Yes.
Senator McKay,
I'm gonna, I mean. It's not.
It was a rough dinner last night. Yes.
Senator Carter,
No, and briefly explaining my vote, it really should not be an issue where we're excluding any one or particular group or entity. Either you believe that entities and, everybody should be responsible for negligence and be liable for negligence, or you don't. You don't say that this one major conglomerate can be exempted for liability for negligence. And what these clauses do is they allow these entities to escape liability for negligence. And so a child, an old person, a human being harmed is still going to be harmed no matter what the location is. But in these particular situations, if you exclude this major conglomerate or any entity, then you essentially allow them to escape the same obligations under the law that everyone else has. And so for those reasons, I think it's a terrible decision. No disrespect to the sponsor of the amendment. I know that she's well-intentioned and I completely understand her rationale. I just think it's a terrible precedent. Either it's like either you believe in liability for negligence or you don't. It doesn't matter who does it and who doesn't do it. It's kind of like, it's kind of outrageous that we even would make that distinction.
I don't know if we're in the. So when this bill was brought up last year, I brought up pools and wanted them out in general. And that didn't fly. So I'm just letting everybody know, we kind of already voted on this and it left out with including pools the last time. So I'd like to change my vote to no. To be consistent. I'm just being consistent with what I was last year.
I would like to just point out that the reason for this amendment is also because of the physical components that they're affording people that go to these, like I stay at a long-term facility when we're down here or hotel and they've got a workout room. It's considered a recreation area. So if I go in there on a treadmill and fall off because I'm down here listening to this all day long and decide to fall asleep on the treadmill and bang my head, is that my fault or is that their fault for providing a service for me? Exactly. But this by going against this.
Then how would they be negligent if that should be here on it?
Promise.
If you drown,
Both.
right, and if you drown in a pool that says no lifeguard on duty, then whose fault is that? This pulls them into that. This amendment would allow them to say it's your fault.
Liability.
Mill is broken.
Then it's not moving.
If it's, no, it could be it could be moving and still be broken. If they've not repaired it in such a way, then it's on them.
All right.
And you
I
signed a waiver saying that it was.
I still press my
The issue-
approval of this
the issue
adoption
is
of this
the signing
amendment.
Of the waiver, signing your waiver, your rights.
I just want to make sort of the case, how do I put this well? So for me, this is entirely about process, right? I can't make a decision about whether I agree with Senator Carter or not in terms of whether hotels should be included in this, because the hotels did not think they were included in this. They were told by the lobbyist that they were not intended to be included to this. They did not show up at the hearing because they thought they were not included in this. It is my understanding that there are not a lot of hotels that use these types of liability waivers, but we don't have any of the information we would need to make a responsible decision about whether we should include hotels in this legislation or not because of how this process has unfolded. I am more than happy to consider including them next year once we've gone through the process, but I don't think it's fair to include them when we haven't understood it to include them.
Interestingly enough, I hear you and I understand your rationale. I just have the complete opposite rationale. Last year, we passed a bill about training for security guards. And at the 11th hour, very similar to this, after the hearings were held and the votes were in the process of being taken, the hospitals jumped up and said, hey, we want our security excluded because, you know, this happens every day. It's an everyday occurrence for us. They didn't participate in the hearings and the train had left the station. And so we passed the bill and guess what we did? We came back this year with a bill because they've now been able to convince us that their situation may be a little different. And the bill that we have before us this year potentially excludes them or modifies, you know, their role, their ability to be caught up under the training requirements of the security guard bill. And so my suggestion is to pass the bill. And if they want to come back next year with a bill and have hearings on it and hear both sides of the issue, then that's fine. But I don't think that we exclude them when they didn't even bother to come in. And to say that sophisticated entities such as this listen to a lobbyist say you're not excluded and that was the basis for why they didn't oppose it, that just doesn't make any sense. So
who resides in the same district. It's like, no, they know.
Chairman Schmidt.
You want to say it?
Do the right thing.
All right, let's move on to the next one. Next amendment.
Chairman voted yes.
I did. All right, next amendment.
So the amendment fails.
The amendment prevails. I voted yes.
Fails to take it out.
Yeah. Yeah. All right, next amendment.
The next amendment, Amendment 953-821/1 in your packet. That amendment would say that this section does not apply to a health club services agreement as defined in 14-12B-01 of the commercial law article. And a health club service agreement means an agreement under which the buyer of health club services purchases or becomes obligated to purchase health club services to be rendered over a period longer than 3 months. The seller of a health club services agreement collects more than 3 months payment in advance, and the service to be rendered under the agreement is for personal, family, or household use. There was an amendment that was just requested during the voting session that would make this amendment only, or it would be a separate amendment, but it would just say in concept that this section does not apply to a health services club or to health club services agreement as defined in 14-12B-01 of the commercial law article between adults. So if you're an adult going to the gym, then you would be able to sign these agreements waiving negligence.
This. The exculpatory clauses should not apply to adults. Okay. All right. How is it drafted? Because I don't see it.
Yeah. 1 second. Let me pull it up. And so the amendment would read, this section does not apply to contracts or agreements between adult persons and providers of health club services as defined in MD Commercial Law Code 14-12B-01D2.
Stand, because from what I'm thinking now, I'm thinking it makes no sense. So the way I'm understanding what you're saying, Shamari, is that I, as an adult parent, could not sign, or the agreement couldn't exist for my child, but my child and I could go to the same place and experience the same piece of equipment and the equipment be bad, but only my child could recover if harmed, but not me. Would that be correct?
Yes, that's
So
under that
they
amendment.
get to be negligent when it comes to people over 18, but not children?
Correct.
That makes no sense.
Only at health clubs.
They should be where?
No, I get it, but if you're trying to capture the kids.
Trying to not just capture children. That might be a good reason to do it because a lot of children are impacted, but it should not be, if you have a 80-year-old aunt or uncle or grandparent, they shouldn't be able to be harmed because of negligence where a child can't. And frankly, neither should a 40-year-old.
This has been the session about accountability. We want to talk about juveniles being accountable, but we can't hold corporations accountable for being negligent. Just doesn't make sense to me.
I have to put this in.
Sorry, what was the question? So you go to the gym, you sign a contract saying that you release the facility from liability for negligence. So under this amendment, you can sign away, you can waive negligence as an adult, but as a child, as part of that agreement, you cannot under that last amendment.
That's the question.
That's That's unclear from the drafting, and it hasn't, I haven't,
That's what the.
Yeah.
Can we get it to where
Can we?
that's clarified or added that?
Do you need to do that in line or do you need a weekend to do that?
I could probably do it over the weekend.
Yeah.
I don't want to do it sloppily.
Let's do it on Monday.
Okay.
Right.
Boom, boom.
Are you holding it with? the
With that first,
amendment?
no, the whole thing, we already voted on that amendment, so. We already voted on the first amendment,
Yes, that's what I'm saying, we're holding it with that amendment.
Yes.
But not the second one.
not the second, because we haven't voted on it.
Yeah.
Okay. All right, one last bill. We do have the letter. That was last, we have we got that delegation letter. Do you want to, Baltimore County?
It just came.
Go ahead.
I'm sorry. John.
Is everyone okay?
Yeah.
But there was an amendment.
That's one way to get agreement, just keep these things late.
Oh, so can you please explain the amendment?
So the amendment that the bill as drafted puts the responsibility on Baltimore County. The amendment would transfer to the State Highway Administration.
It just transferred.
Yeah, so under the bill, Baltimore County can set up to 16 speed cameras on 695 and have 4 active at a time.
Is everyone okay adopting the amendment? All right, now the bill's before you as amended. Motions for a favorable. It's been seconded with amendment. All right. Bill passes unanimously with amendment. Have a great weekend. That was awesome.